this is a bit of a different question to what you often see. So the kind of standard question you often start with is, what is law? And that's quite a hard question to answer. And I like to ask that question a bit of a different way to begin with, at least, and just to say, what does law do? Rather than what is law. What is law doing? What is it supposed to do? What does it actually do? Even that is a pretty big question, but we can start to try and answer it a bit. And we can start answering it by first looking at the different areas of law. So we can broadly define law into 3 different areas. First, criminal law. Criminal law is the state telling you what you can't do, and if you do it, the state punishes you. So the state, the government, is regulating the behaviour of individuals. Now, what I mean here by state, I don't mean state in the sense of states and territories. The state is the government, federal government, state government. The state is regulating the behaviour of individuals, and it can do that with fines. It can do it with putting you in prison. In some jurisdictions overseas, the state can kill you. And this is something the state is sort of set up to do. If you think about state institutions like police, like courts, like prisons, sometimes we see this as an area of debate around, the limits of the criminal law, what should be criminalised, what penalties should be put in place. It's an area of real political debate and theoretical debate around the boundaries of the criminal law. Then we have civil law. And civil law is regulating the rights and the duties between individuals. So if I gave you an example of civil law, I could say, well, let's say I sell you the laptop that I'm recording this lecture on. And then what happens is you don't pay me for the laptop. So I sue you. That's civil law. Or let's say, while I'm recording this lecture, you walk into my office and you knock my laptop on the floor and you break it. Again, I sue you. That's civil law. Civil law doesn't just apply to individuals, it also applies to companies, corporations. So we could also say, if my laptop breaks down while I'm in the middle of recording this lecture, I sue Apple. That's civil law. The law is operating here to help us try and obtain what we think is owed to us by other people. Now, the thing about civil law is that it's pretty complicated as to whether we can actually use the law, use the courts, to get what we think is owed to us. So in that last example, Apple, so I sue Apple, Apple has a lot more money than I do, and they have a lot of lawyers. So this is something that we want to think about when we're thinking about civil law and the civil justice system. It has to work to support access to justice. It has to work to support me to put my case across, even when I'm competing against a big corporation, a big powerful opponent like Apple. And then finally, public law. Public law determines the relationship between the individual and the state. We can see some crossover with criminal law, but it's something a bit different. When we're looking at public law, we're saying, well, the state decides I can't do something, or the state decides I have to do something. Public law is the way I'm going to try and get those decisions looked at. That decision to make me do something, that decision to stop me doing something, I use public law as the route to have that decision reviewed. In public law, we see state decisions, their effect on individuals, being looked at, being challenged, being reviewed, that kind of thing. So that's public law. We can also divide law in terms of types of law, in terms of substantive and procedural law. So substantive law is the law that we're probably most familiar with, and that's the law that says what you have to do, what I have to do to obey the law. And then procedural law is more kind of the law for the legal system. It's how the law works, what the justice system has to do, what law has to work within in order to kind of maintain that integrity as a legal system, so that you can maintain the integrity of legal processes. That means procedural law is very important for lawyers, because lawyers are working in the legal system. They have to uphold the legal system. And so as lawyers, we don't just use substantive law, the regulation of what you have to do and not do as an individual. We also have procedural law being really important for us because it's the law of the law, and we're working within that system all the time. One more division is jurisdictional divisions. So we can divide law into jurisdictions, and very broadly we can talk about domestic law and international law. Domestic law, law within Australia. International law, law from outside Australia that applies to Australia. So domestic law applies in Australia, international law applies to Australia. This is where we think about something like a treaty or a trade agreement with another country. That's a piece of international law, and it doesn't necessarily apply to you or me in a domestic legal context. International law, before it applies in a domestic context, has to be incorporated into domestic law. Because the domestic law and the international law legal systems are actually separate legal systems. They're separate jurisdictions. They have different areas of authority and different ways of making law, enforcing law, applying law. So there are different jurisdictions, and obviously jurisdictions is something we'll come back to more, because in Australia we have the federal and the state system. So maybe we've gotten a bit closer to figuring out what law is, but the important thing here to realise is that very prominent, prestigious theorists have argued for a very long time over what law is, and probably we still don't quite know. We still don't have quite an agreement on what law actually is. So we could maybe start by saying, well, is law a system of rules? Is law just another word for a rule? And probably we can't really say that, because at most we could say that all law is rules, but not all rules are law. Not every rule is a legal rule. Beyond that, we might disagree even more than that. We might say, well, law isn't actually comprised of rules. Law is a bit more complicated, and that's something that a theorist called Ronald Dworkin presented as their theory of law. That law wasn't rules, it was principles. It wasn't so narrow as hard and fast rules. Another area of debate and disagreement is the relationship between law and morality. If we try and work out whether law is just a kind of application of a moral code, well, there are definitely lots of connections between law and morality, but does that mean there's a one-to-one match? It's not so clear. Is it causation or correlation, that relationship? It seems like moral ideas have been very influential in the law and the way law has developed, but that doesn't apply everywhere. There's lots of law that doesn't seem to have much of a connection to morality. It's more about, if we use the example of corporations law, having efficient financial processes, things like that don't really seem to have much moral content. On the other side, you've also got things that are immoral, but not illegal, or at least arguably immoral, but not illegal. And then the final question is, is law just telling us what to do? Because I think when we first think about law as a system of, regulating behaviour, telling us what to do, telling us what not to do, a lot of law does seem to do that, but a lot of law is also facilitative. It enables us to do things. There are lots of questions here about what law is actually doing, about what the law is doing, what the law should be doing. There's no straightforward answer. But at least we can start to think a bit about what the law does. The law determines what activities are acceptable. It does so by resolving disputes. It does so by setting standards for activities, for behaviour. The law imposes penalties or consequences for particular behaviour. We can see that as maybe enforcing a social order. Law enables or encourages activity perceived as socially or economically beneficial. So in doing so, it can reinforce the values of those activities, promote them. And law regulates particular activities or functions, for example, corporations, the financial sector, or tax. When we're talking about law, we also want to think about why we have these laws. And there are a number of reasons we can point to for having law, for having a legal system. So law can maintain public order and safety. Law can keep us safe. It can set standards. This means we know what we can do, what we should do, what we can expect from others, from the state. Law can also maintain public order and safety through protecting expressions of free speech, things like that as well. That idea of law protecting individual rights is really important. If you think about what law can do to prevent us being arrested or even tortured for peaceful protest. Law gives us a way to respond, a way to protect us from these kinds of things, and that's because law gives us a right not to be tortured, or a right to exercise freedom of speech and freedom of thought. Law can also enable political progress, so it can actually serve as a way of developing awareness, developing understanding. Law also regulates our economy by setting the rules of the transactions that take place within that economy. In doing so, law isn't just resolving disputes. If you think about tax law, a lot of tax law, it doesn't really engage with disputes. It's about regulating transactions, enabling those transactions. Now, one of the debates in law is whether the legal system is enabling the right kinds of transactions in the right ways. The debate over whether the law is exposing us to financial risks or other risks is something we have to think about. Law also enables us to interact as people by setting the terms of our interaction, by setting the rules of those interactions. Hopefully in doing so, the law can help us resolve disputes. We have some issues that we'll see later in the term around how much it costs to resolve those disputes. And law can also hopefully protect disadvantaged people within society. Although again, we might have to look later in the term as to whether it's doing that. The other thing law enables is states to interact. If you have consistent legal standards between states, then that might give us a way to avoid international legal disputes. It might even give us a way to avoid wars. And then finally, law can provide a way to guard morality, to stand up for what's right, to prevent bad, quote-unquote, things from happening. Now the thing about that is, whose morality are we upholding with the law? Who gets to decide what's good and what's bad? And that brings us to an interesting question around where law comes from. We said law comes from the state. It comes from a voice of authority, an entity that has the authority to make and enforce law. Remember that the state is really set up to run a justice system. It has the facilities, it has the institutions that enable a justice system to work. Things like a federal government, things like a state government, things like the judiciary. But we also have to think about who's telling the state what to do. Where does the state get its ideas? Is there some inherent morality just kind of out there in the ether that we all share? Is there some way that we effectively communicate preferences to the state? I'm thinking here about voting. Or are we concerned about whose voices are being amplified in communicating to the state? Do we think that the loudest, the most powerful, the people with the most political or financial influence are dominating that debate? Or are we concerned that individuals within the state system are applying their own personal beliefs to the law and the way it works and applies to the rest of us? These are really big questions, obviously, and they're questions that we'll come back to over the next few weeks. They're questions that I think help you to understand why law is so important and why it's so important to have the fundamentals in place when you start your legal studies. Because it's only by having that grasp of the fundamentals that we can even engage with some of these more difficult questions. In this unit, we spend a lot of time thinking about law and what law is. But we also need to think about who lawyers are and what lawyers do. What does it mean to be a lawyer? Some lawyers are practitioners, lawyers in practice, barristers, solicitors, legal executives, judges. But lawyers aren't just legal practitioners. Lawyers can be economists, politicians, academics, journalists, activists, even artists. Legal knowledge and thinking can be applied in all sorts of different ways. That means being a lawyer can mean all sorts of things. Maybe you'll define your own way of being a lawyer. Find a new avenue in which to use your legal skills. But it is important to have an idea of who lawyers are and what they do. Lawyers do a range of things. In legal practice, they might have specific tasks, like advising clients, interviewing witnesses, drafting documents, and presenting arguments to the court. But these tasks are all instances of a broader idea of what lawyers do in lots of contexts. They work with and communicate with people. They understand the law and the situation in which they're applying the law. They use their knowledge to respond to the factual scenario and the needs of their clients, solving complex problems. So lawyers work with the law, but they also work with the facts and they work with people. And in all of their roles, lawyers exercise professional judgment. Exercising professional judgment is really important. Lawyers are often in positions of responsibility, either responsibility for others or for themselves, in upholding their reputation and the reputation of their profession. Lawyers have to decide what's best to do next, what will fulfill their role as a lawyer best, thinking critically and carefully, and engaging in reasoned thought processes on the basis of evidence is fundamental to what lawyers do. In part, that's because lawyers can have an important role in society. Lawyers protect the rights of clients and other affected parties, these stakeholders in the justice system, but they can also promote legal and political reform. And in this way, either in court or in lecture theatres, lawyers can be activists. But you might think that lawyers shouldn't be any of those things. You might think lawyers should be servants to commercial or political interests. You might think that's the correct role for lawyers. And that position is entirely legitimate. What matters is what you think of yourself. If you're in this unit, you're a lawyer, which means that you're joining a profession, and you have to start thinking about what it will mean for you to be a member of that profession. What will it mean to you to be a lawyer? For now, that's all I've got to say. That wraps this lecture up. If you're thinking about what we've engaged with this lecture and you're thinking, wow, this is a lot, don't worry, because there's two things here. One is it will get easier. This stuff will become easier over time. You'll get used to the idea of legal thinking and working within the legal system. And the other thing is, as I say, there are no easy answers here. These are big questions around the legal system and what law does. All we want you to do is start thinking about them, because thinking about them will help you on your journey to becoming a lawyer. Have a great week, and thanks for listening.